Good morning to you all, and welcome to the ENS Africa Mine Health and Safety webinar, where Willem Leroux and Celeste Coles will deal with the current impact of COVID-19 on mining operations, as well as the measures and notification requirements in terms of the National Health Act and applicable regulations. Warren Hendricks will deal with the new trackless mobile machinery regulations, and all speakers will comment and provide input in respect of all these topics during the webinar where required. Willem is an executive consultant in ENS Africa's Mine and Occupational Health and Safety Department. Willem was the lead lawyer advising the then Chamber of Mines, now the Minerals Council, South Africa, during the Leon Commission of Inquiry into Safety and Health in the mining industry. For many years, Willem has been advising and representing employers' organizations and various prominent mining groups, as well as other groups outside mining in a wide range of matters. Willem is also the author of Mine Health and Safety Law, a very influential loose-leaf commentary published by LexisNexis. Celeste and Warren are directors in ENS Africa's Mine and Occupational Health and Safety Department. They are very experienced and technically skilled lawyers and have over many years been involved in various prominent matters in and outside the mining industry. My name is Pieter Culain, and I'm the head of ENS Africa's Mine and Occupational Health and Safety Department. I'm honored to host today's webinar and request you to please enjoy it and participate in an interactive manner. So please feel free to pose your questions at any stage during the webinar under the Q&A function, which forms part of the Zoom platform on which this webinar is being presented. Willem, Celeste, and Warren will aim to deal with such questions during their presentations, and we will also answer some of these questions in our communication to you following the webinar where required. We have your email addresses and will also email the PowerPoint slides presentations to you after the webinar. The webinar will also be made available on YouTube for you or your colleagues to view later on. We aim to conclude the webinar by 10:30 this morning. And now, without further delay, let me start today's webinar by asking Willem to please conduct the first presentation.
Yeah, thank you, Peter. Celeste and I will deal during the first two presentations with COVID-19. I will deal with the notifiability of the disease. And those things are very important. I mean, we must keep in mind the legal obligations. So we know that COVID-19 was declared a national disaster on the 15th of March 2020, carried on for about 2 years, and then it was revoked as a pandemic, being in this particular instance, a national disaster on the 5th of April 2022. So now the question is, what must we do now? Does it mean that suddenly after the revoking of the national disaster relating to coronavirus, we don't need to do anything, or what are the requirements that we must comply with? And a further reason why I address this is that on the 3rd of February 2023, there was a regulation issued in terms of which monkeypox was declared a notifiable disease. And then in that same regulation, the minister attached two tables, Table 1 and Table 2 of Annexure A, setting out the notifiable diseases. And coronavirus, COVID-19 was left out. Now, what does it mean? Does it mean that they've revoked it? You don't need to report it? Okay, we will deal with all that. I will start analyzing these provisions of the Act and regulations by dealing, first of all, with the question, who must report the medical condition? So let's have a look at that. Okay. Right, who must report a medical condition? A healthcare provider who diagnoses a patient with a notifiable condition listed in Annexure A, Table 1 of the regulations relating to the surveillance and control of notifiable medical conditions must report the medical condition to the Department of Health. So we're going to analyze that. Who must report? In what circumstances must it be reported? And what is a notifiable condition? So let's move on and look at the further requirements. To whom must the report be made? The report must be made to the focal person at the health sub-district of the department, and you will find that in Regulation 1318. Now, of course, it's very strange that the word focal is used in the regulations. You don't really come across that, in other legislation. And this is the only instance where in the National Health Act and the regulations, this term has been used. But you can accept that refers to the responsible person. Now, who is the responsible person? You will find that the NICD, being the National Institute for Communicable Diseases, they receive these notifications. There is an NMC application on the net where you will find the form, and you will find also a telephone number where you can report these things. But let's have a look at the further obligations. To whom? When must the report be made? This is very important. The report of the medical condition, which is listed, must be made by means by the most rapid means available upon diagnosis. So you don't need to report it when you suspect it. It must be diagnosed, okay? The regulations say that even before the case is laboratory confirmed, in order to facilitate the implementation of the public health measures and response, this must be reported. And then that is not where it stops. Secondly, the report in respect of the medical condition listed in Annexure A must be followed by a written or electronic notification within 24 hours of diagnosis in order to facilitate the implementation of the public health measures and response. So, first of all, it must be a Table 1 disease. And secondly, then you must notify it as soon as possible by the most rapid means available. And then you must also send an email. Then, thirdly, if it is not a notifiable disease in terms of Table 1, but it is notifiable in terms of Table 2, then the report of the medical condition must be made within 7 days of diagnosis by means of a written or electronic notification in order to facilitate the implementation of the relevant steps. So then the reporting requirement is a little less stringent. You don't need to report it by means of an email straight away. You can report it, but as long as you report it within 7 days. But let's have a look at now what is reportable, what is notifiable. If the medical condition is listed in Annexure A Tables 1 or 2, it must be reported. That's clear from Regulation 13.1 A and C. Then further, let's have a look at further requirements. If a healthcare provider who diagnoses or treats a patient with a notifiable condition in terms of tables 1 and 2, and the patient subsequently dies as a result of the condition, then the healthcare provider must report the death to the focal person at the health sub-district level of the department by the most rapid means available in order to facilitate the implementation of public health measures and response. And then further, again, it must be followed up by a written or electronic notification within 24 hours of diagnosis. So that's very important that you keep that in mind as well. It's not only reporting it in the beginning upon diagnosis, but also in the event of death, if the death resulted as a result of the condition. Then, further requirements. Let's have a look what is a healthcare provider. Now, the words healthcare provider are defined as meaning, amongst others, a person providing health services in terms of any law, including in terms of the Health Professions Act, number 56 of 1974. So that will include the OMP, the Occupational Medical Practitioner, appointed in terms of Section 13 of the Mine Health and Safety Act, and also any other person who is now covered in terms of the Health Professions Act and who also provides health services. So it will not be the employer, that being the mining company, who is the healthcare provider, because remember, that is the person who diagnoses the condition. And it's unlikely that your CEO or other manager who's not a healthcare provider will now provide health care. It's indirectly provided in that the company appoints the occupational medical practitioner, but the provider is the occupational medical practitioner. It can be argued that even the nursing sister must also report it if it's not reported by the occupational medical practitioner. And remember, it must be reported as soon as the condition is diagnosed. So when do you diagnose such a disease? And the word diagnosis and diagnose is not defined in the regulations or in the National Health Act. So you will follow the general meaning, which you will find in dictionaries. In the Oxford or in the Cambridge University Press and Assessment communication or electronic dictionary, it is devised as being to recognize and name the exact character of a disease or a problem by examining it. And also in the Oxford Dictionary, it is to identify the nature by examination of symptoms of the disease. But the point is this, it is not when you're still speculating whether it is COVID or not COVID. Is it now a normal flu or is it no COVID? It is a situation when the healthcare practitioner becomes convinced that it is COVID-19. For example, the person has been tested for COVID and the test result was that, in fact, the person has got COVID. So that is when the healthcare provider must then report that disease. But so let's have a look at COVID-19 as a notifiable medical condition. That is where there's not complete clarity at the moment. The words respiratory disease caused by a novel respiratory pathogen was included as a notifiable medical condition under Annexure A, Table 1 of the 2017 regulations, even before the declaration of the national state of disaster in March 2020. That is a generic description. It's a genus. And so a couple of things can fall within that group of medical conditions. Then, in terms of table A, table 1 of Annexure A, a novel respiratory pathogen includes novel influenza A virus and MERS, Middle East Respiratory Syndrome, coronavirus. So that is then coronavirus and what we called also COVID-19. And that is because it's caused by a novel respiratory pathogen. And so for that reason, even as early as 2017, it was clear that that had to be reported because it was notifiable in terms of Table 1 of Annexure A. Then the fourth bullet. Despite the above, the Minister of Health declared coronavirus disease, COVID-19, as a notifiable medical condition listed in Table 2 of Annexure A in terms of certain government gazette of 4 May 2022. So now the question is, why was that published if it had already been required to be reported? And in fact, as you would have seen, or as I pointed out, there was a 7-day period within which you had time then to report it electronically in respect of Table 2, whereas in Table 1, you must report it electronically within 24 hours after you've reported by rapid means available of reporting. So, but perhaps it is for clarity. We're not sure. But let's have a look what happened further to this declaration. In terms of that, the latest notice published by the minister in terms of the Act, a respiratory disease caused by a novel respiratory pathogen is listed under Table 1 of Annexure A as a notifiable medical condition. So a confirmation actually of what happened in 2017. The listing of such medical condition, including the reference to coronavirus COVID-19, is no longer listed under Table 2 of Annexure A. So, and that is the notice which was published when monkeypox, when that was required to be reported as a notifiable disease, then they attached also the 2 tables to those regulations. And in those 2 tables, you don't find the specific reference to coronavirus COVID-19 any longer. Now, what is the conclusion? Must you now conclude that it has been scrapped? You don't need to report it any longer? Or is the intention of the department just to deal with it under Table 1, as they've done since 2017? No, it's not clear. I made inquiries from the Department of Health, and the top person in charge wasn't clear on it. So I was referred to some other people who would have clarified it, but after some time, I have received no clarification. So the point of the matter is, I don't think that one can argue that by scrapping the reference to coronavirus COVID-19 in the latest notification of 3 February 2023, one can conclude that it's no longer required. The reporting is no longer required. And in any event, the minister can't just leave out things. The minister can declare regulations, and by imposing certain requirements, or by changing it, or by deleting it. So this procedure hasn't been followed. So perhaps something unknowingly and unintentionally was done, as we know nowadays happen very often especially with Eskom and so forth. So my advice is report it in terms of table 1. When it's diagnosed by the healthcare provider, report it straight away by telephone. And you will find, as I say, on the National Institute of Communicable Diseases on their website, you will find the telephone number, and then you must also report it electronically within 24 hours. And then, lastly, remember, this obligation is very, very important, because if a person fails to comply with the provision of the regulations, then the person is guilty of an offense and on conviction liable to a term of imprisonment not exceeding 10 years and or a fine determined by a court of law. So the amount of the fine will depend on the jurisdictional capacity of the court. Is it the magistrate court? Is it the regional court? Or is it the high court? So it is very serious. And of course, it's important that it be received a very urgent and immediate attention when it occurs. As we've seen now this morning, I heard reports about cholera, which was discovered in respect of a number of people. And the suspicion is that perhaps it was because of use of water in the Yixkay River. Cholera is a notifiable disease in terms of table 1 of Annexure A. That must be dealt with then as soon as possible. Healthcare measures must be taken. So as far as the mines are concerned, when a person reports and it is not clear whether he has COVID and he's suffering from certain of the symptoms, ensure that the person is then tested for COVID. And if the test is positive in the sense that he's got COVID, then of course you must report it straight away. And then you must take other measures with which Celeste will deal with. Thank you.
Thank you, Willem. I appreciate the insight regarding the reportability of the COVID-19 virus. My part of the presentation relates specifically to the obligations currently in place at mining operations relating to dealing with and treating with the COVID-19 virus. Once one started down that road, it took me some time just to establish what the actual position is and where we are with everything. But in essence, I decided let's start at the actual beginning, and we will talk through where we were in 2020. So Willem has already referenced the national state of disaster that we all remember with trepidation on the 15th of March 2020, where in terms of the Disaster Management Act, various regulations were imposed, various measures imposed on different alert levels. And there the focus was really the control of the pandemic, spreading or preventing the transmission of the COVID-19 virus and the consequent impact on our healthcare facilities, healthcare providers. And then obviously the main aim was minimizing the amount of deaths attributable to the virus. And in that period of the lockdown, we had really strict measures for quarantining, isolation, testing, prohibition of mass gatherings, the conduct required from persons when entering into public spaces, and all of that tied in then to the mining industry. And in consequence of the disaster, the state of disaster that was declared in terms of the Disaster Management Act, and then as well as litigation that was actually brought by AMCU and other interested parties. I think Willem and Warren were involved in that, where there was a court order compelling the mine and the Chief Inspector of Mines to take measures regarding the treatment of the COVID-19 virus in the industry. We then had a guideline issued to the mining industry, which compelled the mines to compile a mandatory code of practice for the prevention, mitigation, and management of COVID-19. So we had the first government gazette notice on the 18th of May, which was what we call the initial version of the guideline. And then as the state of disaster developed and as our various alert levels moved and as measures changed and the situation changed, we then had on the 6th of August 2021, the guideline issued again, which I've now termed as revision 1. It was never clearly set out in the actual government gazette notice how the two would interact, but that general acceptance in the industry is that persons are then going to work off the 6th of August 2021 guideline. And the expectation then from the mining houses was to implement the COP, obviously utilizing the guideline issued by the Chief Inspector of Mines. And it's important to note that that guideline is then issued in terms of Section 9 of the Mine Health and Safety Act, which makes it a mandatory code of practice. So the terms of the guidelines, a mining house must comply with the terms of the guidelines and have the COP in place at its operations. Pause at this juncture to obviously note that on the 6th of August 2021, when this revision 1 was published, the circumstances and the prevailing measures dealing with the COVID-19 virus was dealing with what we knew at that stage. I think the vaccines were starting to come into play. They were starting to sort of be rolled out. That we were still very much in the phase of travel restrictions, quarantining, isolation, and all those other rather strict measures that was felt to be necessary in order to control the spread of the virus. Because it's a dynamic situation and it was ever changing and the literature changed and there were developments and the research indicated certain developments, the decision was then, I think Willem also did mention that right at the beginning of his presentation, that on the 4th of April 2022, there was a government gazette notice which terminated the state of disaster. The effect of that termination of the state of disaster was that all the regulations that had been issued and published during the state of disaster dealing with various departments and measures in place for the COVID-19 virus and measures was terminated with immediate effect, except with regulations 67, 69, and 75. And that dealt with public spaces, wearing of face masks, etc. But it must be noted that those particular regulations were then lapsed on the 4th of May, 2022. So even though they had a month where it sort of was in place provisionally, they then formally lapsed on the 4th of May, 2022. As far as regulations that were published during the course of the state of disaster, the only chapter that still to date remains in force and effect is Chapter 8, and that deals with the COVID-19 vaccine injury no fault compensation scheme. But that's a topic for another day, for another issue. In consequence of then the repeal or the termination of the state of disaster and the repeal of all these regulations and a change in circumstances, there has been no government gazette notice issued with a guideline revised by the Chief Inspector of Mines. So nothing further bar the 2021 revision 1 that I referenced earlier is in place in effect. However, in 2022, about the 28th of June 2022, there seems to have been a letter authorized by or on behalf of the Chief Inspector of Mines. We have not been able to ascertain whether that particular correspondence was transmitted to the mining houses. It appears to have formed part of some form of discussion by the tripartite forum at the time in June 2022. But what we have managed to establish is that versions of that Chief Inspector instruction have then been copied into correspondence by principal inspectors of mines and distributed to regional offices or regional mining houses. Carbon copy of the chief inspector's letter. So we've accepted that those directives then have been communicated to the mining industry. And in essence, this correspondence sets out guiding principles, which indicates that the chief inspector of mines has imposed revised measures for the prevention, mitigation, and management of COVID-19 pandemic in the South African mining industries. And in essence, what that correspondence has said is that the COP remains in force and effect, my guideline remains in force and effect, except for these categories where you may then amend your COP to coincide with the current provisions and prevailing legislation and measures. I'm going to talk through it very quickly, just in essence, and tied into the correspondence at that period. So the first thing that was in place is the wearing of masks. There is no obligation or mandatory requirement to wear masks. It did indicate in the letter that you would have to comply with the prevailing Department of Health legislation and policies. And at this juncture, the Department of Health does not have any legislation or policies in place regarding the wearing of masks. However, the revision does mention that, most importantly, your mine risk assessment must still come into play. So, and I'm going to repeat this at the end of the day, the mine's risk assessment will dictate the measures that the mine implements at its particular operations relating to the management and control of the COVID-19 virus. So that is your focal point as a mining operation, to make sure that not only your risk assessment takes into account the current and prevailing literature and circumstances, but that you also take into account your mine-specific conditions and operations. So even though there may not be an obligation to wear a mask in general and in public, in a shopping center or in the office building, your mine risk assessment may indicate in the very extreme confined stope environment that a mask or a certain type of mask may be beneficial to your operations. And that's an example. I'm not saying that is in fact the prevailing literature. Gatherings was another aspect that will be revised, and the correspondence indicates that the prevailing Department of Health legislation would apply, and at this juncture there is no legislation or policies prescribing any measures that must be taken relating to COVID-19 at mass gatherings. Social distancing, same requirements. There is no National Department of Health official policies or legislation, but again, the correspondence referenced the mine's risk assessment. Mine employees entering or leaving the country, again, the correspondence says, okay, you must comply with the Department of Health's legislation and policies, and as time has progressed, you will note that, and if you travel, you will know that there are no restrictions in South Africa in and out. You do not require any PCR testing further. You do not require any requirements to quarantine for a period of time. In actual fact, they do not stipulate a requirement for a vaccination as a mandatory requirement to enter into South Africa. So as it stands, there again is nothing in place. COVID-19 screening, a focus has been placed on an employer's obligation to facilitate education and training, and I'm assuming it's some form of communication, briefing, for the identification of, and the correspondence refers to such symptoms. I'm assuming the such references COVID-19 symptoms, that persons, when they're entering, other persons are trained to identify the symptoms of COVID-19. But taking into account that they have rescinded the requirement to fill in any screening questionnaires or thermal screening. So I'm not 100%, I'm not a medical professional, what persons would be looking out for visual symptoms, for where the person has perhaps just normal flu symptoms. And the other focal point now is that employees and persons entering the mine are encouraged to self-report their medical condition and whether they feel unwell, and if they suspect that it's COVID, or if they are suffering, or if they have been diagnosed with COVID-19. If a person does self-report that they have indeed tested positive for COVID-19, the guideline in your COP has provisions regarding that person being under investigation, and the person would then be treated in accordance with the guideline and the COP, except for persons who have been vaccinated and they then displaying symptoms within 1 to 3 days. They would not then fall under the category of persons under investigation. Quarantine. There are no requirements in place for persons to quarantine if they test positive for COVID-19 or if they are exposed to persons who have tested positive for COVID-19. The only exception, and that carries through from the National Department of Health, which has then been incorporated by the Chief Inspector of Mines directive, except if you have a cluster of cases, 3 or more in a mine health facility, then the quarantine requirement would kick in. And persons that are exposed to COVID-19, and that then ties in, I just want to point that out, when a person's now obligated to self-report, one of their obligations, and the word used is encouraged, to advise other persons whom they have had interaction with that they have indeed tested positive for COVID-19. Persons are then just required to monitor their symptoms and test and isolate if their symptoms are severe. And I'll go into the isolation requirements now. The directive from the DMRE requires compliance to the National Department of Health again, and the latest correspondence that I was able to locate, and it's not legislation, it's not in any form of regulation, is a memorandum authored by the Director General of Health, and that memorandum is dated the 17th of February 2022, which appears to be the most updated requirements relating to treatment of persons with COVID-19. So in a nutshell, persons that are tested positive, but they're asymptomatic, no need to isolate at all, but they are advised to wear a mask when interacting with persons, avoiding social gatherings, which is defined as meeting with people, with 3 or more people, avoid being socially indoors 5 days from the date of their test, and then they are just to avoid social interaction with the elderly and any persons with comorbidities. So it's a lot of reliance on persons complying with recommendations. Symptomatic, if a person is symptomatic, they distinguish between 2 categories. The first category is somebody who has mild symptoms that does not require hospitalization for COVID pneumonia, and those persons are required to isolate for 7 days from the dates that they started with the symptoms, and there's no requirement to test prior to de-isolation. And then persons with severe symptoms, which means they've been hospitalized, will isolate for 7 days from the date in which they no longer require oxygen therapy. And again, no testing is required prior to their de-isolation. No more requirements for contact tracing, active contact tracing, which was a big thing at the time when the guideline was published. And again, the only exception is if we have a reported cluster of cases in a mine health facility, and the encouragement is listed there for persons to advise other persons that they've tested positive for COVID-19. If there is an outbreak of COVID-19 or any investigations related to containment activities, they only require an investigation in terms of Section 11.5. Now, again, if we have a cluster of cases in a mine health facility. Alternatively, if there is sufficient grounds to suspect occupational COVID-19 was contracted at the mine, and then that investigation is intended for the purposes of submission for compensation, and that would be in terms of COIDA. They do, however, incorporate a degree of discretion, so they require then that the mining houses, and in particular the OMPs, to apply the principles of quarantining, isolation, and contact tracing. Tracing, let's try that again. However, if there is a complex scenario, so they don't give any indication what a complex scenario may be, but I'm assuming if there's something outside of what's seen before, then the OMPs have a discretion to decide how best to deal with this complex scenario, and they have to weigh up safety versus the socio-economic impact of their recommendations. I am not aware of when this discretion has been implemented, and there might be some practical examples that mines may be able to indicate or demonstrate. But as I said, they don't decipher or indicate what an example of what would be considered a complex scenario. The requirements for COVID compliance officer and steering committees, that remains in place. That is still very much alive in terms of the COP, and there is a big importance placed on vaccinations, the drive towards vaccinations, towards having all employees vaccinated, booster shots, etc. And then they also cater for familiarity with the COVID-19 vaccine injury no fault compensation scheme. In a nutshell, after that correspondence, and they've then listed those particular categories where the guideline can be amended, there's a general qualification at the end of this correspondence, which states that for all other provisions that are not addressed in these guiding principles, the prevailing National Department of Health legislation and policy shall apply. However, in designated workplaces areas, the measure shall be determined by the mines risk assessment. So at the commencement of the presentation by myself, I did indicate that the focal point remains on a mines risk assessment, actively reviewing the current COP, the COVID-19 risk assessment, taking into account developments, taking into account governing legislation and requirements, reviewing the risk assessments, and then from there, mining houses are required to review their COP on the prevention and management of COVID-19, taking into account this correspondence by the Chief Inspector of Mines, directing towards amending the COP, and bringing the COPs up to date and in line with the current policies, national policies and directives dealing with COVID-19. So that in a nutshell is where we are. A full review of the COP is called for, and that in summation is what we have established as the current prevailing situation in terms of this. I'm going to hand over to Warren. I haven't really been monitoring, but I don't think there's any questions and answers at this stage for COVID-19. I'm going to hand over to Warren, who will now deal with the other burning issue in the mining industry, which is the directive or the new TMM regulations, which came into force and effect in time for Christmas. Thanks, Warren.
Thanks, Celeste. I think there is a question in the Q&A for you. I don't know if you want to deal with it now. It was by Stoffels Odendaal, and he said, do we need to appoint a legal COVID appointee?
So Stoffels, I didn't see that Q&A, but the requirements for your COVID compliance officer and your steering committee still remains in place. So that is specifically dealt with in the particular guideline. So that remains in force and effect.
Thanks, Celeste. I will deal with the new TMM regulations, which were published about now, it's 5 months ago. So perhaps an undeclared national state of disaster for some, but it's still early days. So it'll be interesting to see how the matters develop as they go along. And I will deal with the requirements. We'll look at the requirements, we'll look at legal options, and then see what would be the best way to deal with this. So as I said, on Wednesday, the 21st of December, 2022, whilst we were all still doing Christmas shopping, getting ready for the festive season, these regulations or sub-regulations were published for commencements. That was 810.12b, and 810.21b. And these, in a nutshell, in summary, required an employer at the mine to provide for so-called anti-collision systems and devices, with the purpose being of those devices, as per the regulations, to automatically retard or stop diesel-powered TMMs in relation to preventing potential collisions between TMMs and pedestrians in the one instance, and then TMMs and other TMMs in the other instance. The provision of such systems, and again, as I was just saying, there's no transitional period that was provided. So these regulations, as per the date of publication in the Government Gazette, immediately commenced. Again, these systems require certain TMMs where there is a significant risk of the collisions which are referred to implement such anti-collision systems or devices. But we'll have a look at that a little bit later. The immediate commencement, so immediate compliance by an employer as defined in the Mine Health and Safety Act at a mine. And this created precarious position for some employers as far as immediate or foreseeable compliance is concerned. And again, also it's somewhat exacerbated by the degrees of approach or application and enforcement by the regulator from region to region. I've heard of instances where individual inspectors in certain regions have approached individual mines and gone for an inspection and requested information relating to their pending compliance. And then in other regions, I've also heard of joint meetings being held between employers and the regulator and the Minerals Council. But there doesn't seem to be a uniform approach as far as application enforcement is concerned. As I've highlighted in the presentation, we'll try and deal with the legal requirements of 810 of the Mine Health and Safety Regulations, where the newly promulgated sub-regulations fit in, the application of those requirements to cases. We'll try and give you some practical guidance and then also look at potential legal options available to an employer and the circumstances where that may be applicable. 810, just a reminder again, going back historically, 810 of the Mine Health and Safety Regulations entitled Trackless Mobile Machinery. That was published on the 27th of February 2015. And as of that date, such regulations commenced within 3 months. That was in May 2015, with the exception then of the sub-regulations 810.12b and 810.21b, which, as we've stated now, that's been published for commencement then on the 21st of December 2022. Again, extracts of those sub-regulations were published by notice on the 21st of December 2022, but it's important that those sub-regulations are read within the context of 810. The Mine Health and Safety Regulations and how they sit within the context of those regulations. So importantly, and as a starting point, for the purpose of the 810 Mine Health and Safety Regulations, trackless mobile machinery is defined in those regulations. And I put the definition up there. This is a mirror definition of that which is in the guideline for the Code of Practice for Trackless Mobile Machinery, but a couple of important points that I've highlighted there. Firstly, it refers to any self-propelled mobile machine that is used for the purpose of performing mining, transport, or associated operations underground or on surface at a mine. And then there are certain exclusions there, rail-bound equipment, etc. Again, it refers to any self-propelled mobile machine, so it doesn't only refer to the employer's own TMMs or operators, employers' operators who operate the TMMs. It refers to any TMM which is used for the purpose underlined on the screen. And you'll see it says purpose of performing mining, transported, or associated operations underground or at surface at a mine. You'll see the word mining there. So to start looking at that purpose, we would suggest you would look at that context of the word mining when it's used as a verb in that context. and we look at the definition of mine when it's used as a verb in section 102 of the MHSA, and that says for the exploitation of any mineral deposit in any other manner for the purpose of winning a mineral, including prospecting. Looking at that purpose and determining then when a TMM would fall within this definition, we would say that the words mining, transported or associate operations refers to a class or category of the type of purpose that it's referring to. And therefore we submit that for the relevant self-propelled mobile machine to be seen as a TMM in the first instance for the purposes of 810, it must be used for mining operations, transporting operations, and I put in brackets, or relating or forming part of mining operations, or any other operations associated with the aforementioned two operations. So this is read together as a class. You cannot separate the particular operations or words. It would be too onerous and too restrictive, I would think. So by way of example, if we then look at trackless mobile machinery for that purpose, I've set out just a couple of examples. So a light delivery vehicle entering a mine to provide catering services at such mine would not fall within the above class and operations, and therefore would be excused from the application of Regulation 810 of the Mine Health and Safety Regulations. Conversely, as I say, a LDV used by a supervisor to drive into the open pit area for him to supervise his employees or subordinates doing mining activities, that would fall within the above class and operations, and therefore 810 would apply in that instance. Whilst any of the TMMs as defined is then used at the mine, there would be a duty on the employer to take reasonable practical measures to ensure compliance with the requirements of 810. There are a number of requirements in 810, and before I get to the particular anti-collision systems, where there are operational procedures that should be drawn up, there should be pre-start procedures that should be drawn, maintenance, etc. And most of them are framed by imparting a discretion on the employer to implement measures that are reasonably practicable in compliance with 810. And again, reason practicable definition throughout the Mine Health and Safety Act, which is also defined in section 102. In this particular context, and going to 810.1 and 810.2, there are certain scenarios that are set out there. 810.1, again, I've just highlighted and underlined a couple of important points. It starts again with the employer must take reasonable practical measures to ensure pedestrians are prevented from being injured as a result of collisions between trackless mobile machinery and pedestrians. That's the first requirement. Then it goes further to say, at any mine where there's significant risk of such collisions, such measures must include at least the following. And 810.1.2, A and B, which is of discussion at this point, 810.1.2A says all underground diesel-powered trackless mobile machine must be provided with A, devices to detect the pedestrian and then give an effective warning, and then 810.1.2B, in the event that no action is taken, then the device should be provided to retard or automatically stop the diesel-powered machine to prevent the potential collision. That's 810.1 as it stands. 810.2, again, framed in a similar light, that the employer should take reasonable practical measures, and as I've said, that's a discretion that's imparted to ensure that persons are prevented from being injured as a result of collisions between TMMs and diesel-powered TMMs in this scenario. Again, it reads, and specifically then mentioned and goes further to say, at any open cast or open pit mine, where again there's the significant risk of such collisions, such measures must include every diesel-powered machine must again be provided with the detection system, and then 810.2.1b, again, if no action is taken to prevent potential collision, further means must be provided to retard or stop the diesel-powered trackless mill machine. And again, that's the sub-regulation of contention. So what do we note from those two sub-regulations, particularly in the context of where we're going to go with the anti-collision devices? So again, each regulation requires the employer to take reasonable practical measures to prevent the relevant collisions. That's the first requirement. At all operations, they take reasonable practical measures that discretion is imparted onto the employer to do so. The general legal obligation then to provide detection or warning systems and anti-collision systems as part of that reasonable practical measures only arises where there's a significant risk of the relevant collisions at the mine as referred to in the particular sub-regulations. So that's when the duty arises then as part of those reasonable practical measures to implement such systems. There's a difference in applications between Regulation 810.1 and 810.2. 810.1 refers to any mine where there's a significant risk of collisions between TMMs and pedestrians, and those TMMs can include diesel-powered TMMs. 810.2 then refers to at any open cast or open pit mine where there's a significant risk of collisions between diesel-powered TMMs. Again, it should be evident that petrol-powered TMMs would be specifically excluded as per the wording of these particular regulations. Again, therefore, and in summary, the legal obligation then to provide for detection or warning systems or anti-collision systems is only required at a mine where there is the significant risk of collisions. I'll get to the point of significant risk further on in the presentation, but if the risk of such collision is not significant at a mine, and we'll determine how we can determine that, then the provision of such devices and systems would be discretionary on the part of the employer. So there would be an election as part of these reasonable practical measures to implement them or not. Similarly, with Regulation 810.2, the legal obligation then to provide for detection or warning systems and anti-collision systems is only required at an open cast or open pit mine, where again there's a significant risk of collision between diesel-powered TMMs. Similarly, if the risk of such collisions is not significant at the mine, the installation of such devices and systems would be discretionary. Again, an election on the employer as part of the reasonable practical measures. Whether the risk of such categories of collision is significant would be informed by a risk assessment process conducted specifically at the mine as envisaged in Section 11 of the MHSA. And I'll touch on that again in the next couple of slides. Further to what I've said, if there is a significant risk of collisions between pedestrians and TMMs, as per 810.1, all underground diesel-powered trackless mobile machines at that mine must be provided with the detection or anti-collision systems, as between TMMs and pedestrians. What does this infer? As per 810.1, this would infer that it's not mandatory for any surface diesel-powered TMM at that mine that is not used for underground activities at such a mine to provide it with such devices. It further explicitly infers that 810.1.2 does not require underground diesel-powered TMMs to detect and then retard in relation to other underground diesel-powered TMMs at such a mine. So that's as far as 810.1 is concerned. 810.2, that refers, and if there's a significant risk of collisions between diesel-powered TMMs at an open cast or open pit mine in relation to, particularly between collisions between such diesel-powered TMMs, then all diesel-powered trackless mobile machines at that mine must be provided with detection and anti-collision systems as between diesel-powered TMMs. Again, it explicitly infers that this mandatory requirement to provide the systems as per 810.2 is strictly only applicable to open cast or open pit mines, as per 810.2. It also infers, as per 810.2, does not require such diesel-powered TMMs to detect or to have detection systems or systems to retard in relation to pedestrians at such an open cast or open pit mine, as per the wording of 810.2. So how do we apply these requirements, and how do we apply these requirements in practice? In the first instance, it must be determined which machinery, which equipment fall within the definition of trackless mobile machinery. I've already explained there are certain exclusions in the definition. There are also a specific purpose that the machinery and equipment must be used for as per the TMM definition to be included as a word within the definition of trackless mobile machinery and for 810 to apply. So that should be done in the first instance. In the second instance, it must be determined at a specific mine if there's a significant risk of collisions between the pedestrians and TMMs at such a mine, as envisaged in the regulation 810.1 of the Mine Health and Safety Act. I've mentioned before, determining the significant risk of collisions. How you would do that is by the conduct of a comprehensive and formal mine-specific risk assessment. That is very important to determine ultimately if the risk of collisions are significant. I say that each mine may yield different results depending on the particular facts and circumstances of each mine. This risk assessment process may be informed by, amongst others, and I've set out a couple of criteria that can be used there to determine previous incidents at the mine involving collisions between TMMs and pedestrians at such mine, and the statistics relating thereto. So again, the effect of such collisions, the determination of whether such collisions have fatal injury or merely property damage as part of a historical accident statistics at the particular mine. Also, what can be taken into account is the frequency or the reduction of such incidents at the mine, perhaps following the implementation of systems to mitigate and eliminate such collisions. For an example, a PDS system. That should also be looked at as far as determining incidents at the mine. What may also inform the risk assessment process, interaction between TMMs and pedestrian at the various underground areas at the mine. Are they separated? Is there walkways provided? What is the interaction like? What's the likelihood of persons interacting with each other at the various underground areas at the mine? Again, to determine the significant risk of such collisions. Another example to take into account, safety measures, existing safety measures and controls in place to mitigate and eliminate the risk of collisions between TMMs and pedestrians at the mine. Again, what can also be taken into account is further possible measures that will be implemented or may be considered for implementation to mitigate and eliminate such collisions. In an open cast area, scattered mining approach, limiting the interaction between TMMs, reviewing of the traffic management plan, widening of roadways, in particular in an open cast scenario, anti-fatigue devices in cabins. All of those could be taken into account as these additional or safety measures or controls in place to mitigate and eliminate. I've mentioned before, if the risk of such collision is found to be significant, then the legal obligation is for all underground diesel-powered trackless mobile machines at such a mine to provide it with detection systems and anti-collision systems as between diesel-powered TMMs and pedestrian. A very similar sort of application would have to happen in the case of an open cast or open pit mine. In this scenario, looking at significant risk of collision between diesel-powered TMMs. Again, similarly, this will be informed by the conduct of this comprehensive and formal mine-specific risk assessment. And it will be informed by similar matters which we've discussed, as would be applicable in the risk assessment for the underground or collisions between TMMs and pedestrians. As previously mentioned, again, if there is a significant risk of collision, then all diesel-powered trackless mobile machinery at such a mine must be installed with detection devices. As between diesel-powered TMMs at such a mine. Further practical guidance in terms of matters to be considered. I've seen in certain regions, the regulator, the DMRE, has required employees to submit implementation plans, schedules, and timetables in relation to their expected compliance with the requirements in the sub-regulations. It would be advisable when doing that, just to consider as an employer the practical complexities, as we state there, of investigating, inquiring, and implementing anti-collision systems at the mine. And also other matters that are beyond the control of the employer before sort of submitting or providing an implementation plan or schedule, even considering such an implementation plan or schedule. I note some of the issues that can be considered there when determining what would be a reasonable time period or implementation plan. You should consider as an employer that you will have to rely on collaborative efforts between multiple and respective OEMs for such an exercise. For instance, there's an OEM for the TMM, and it would appear that some of the OEMs or TMMs do not have their own anti-collision systems, so you would have to rely on an OEM, separate OEM for the anti-collision system, and then also an OEM for the interface between the TMM and the anti-collision system. So potentially you have 3 OEMs that have to come to the table, and for that exercise in itself, for these OEMs to come to the table, negotiate, contract, test, determine compatibility, that may take an extended period of time. So that must be taken into account when submitting these implementation plans, schedules, or timetables. Again, for the OEM, they would also have to consider potential and further product and risk liability, and perhaps have to revise the additional measures in place to mitigate product liability in these scenarios. You'll have to take into account for these timetables the practical and testing application of such systems at the particular mine. That may take an extended, unpredictable period of time with trial and error as you test the particular systems at your particular mine. Again, taking into account health and safety. You don't want an improper introduction or implementation, which creates further risks at the particular mine. Lastly, as I say there, the availability and supply of such systems from the OEMs for the population of the relevant TMMs at the mine. So all of this needs to be taken into account when committing to an implementation plan or schedule or timetable, and not overcommitting and not taking these into account. As we said at the bottom of the slide, it would then be advisable that these implementation plans, schedules, or timelines for compliance should be appropriately qualified, and qualified by the matters that we've set out above, and also matters outside the control of the employer, so that the DMRE and regulators well aware of the committal, but a qualified committal with the issues as I've mentioned here, and realistic timetables that may influence the potential successful implementation. Potential legal options available to the employers. One would be an application for exemption. This could be utilized where the duties or obligations as set out in 810 are either impractical or burdensome on the employer. And it is a potential option to consider as an employer, where you could apply for exemption from either certain parts of the sub-regulations or requirements therein. And that application is made in terms of Section 79 of the Mine Health and Safety Act. And 79 deals with exemptions from part or in all of the provisions of the Act. And you'll see they are just highlighted there. An exemption may be general or particular. It may be for any period and on any conditions that provide for the same overall protection that would result from the full application of the Act. Again, just some practical guidelines, but there's no hard and fast rules here. In this instance, the following can be attended perhaps in an application for exemption. I think it's important to identify the objective of the application in particular circumstances. Do you seek a temporary exemption and foresee that compliance may happen at some point in time? Is it complete exemption? From what portion of the sub-regulation and what requirements? So that must be carefully considered, I would think, at the beginning, determining your objective. Each application will be dealt with on its own merits. I would think also on a stringent basis, perhaps by the regulator, considering the subject matter that we are referring to. So for that reason, there must be detailed reasons in the application. Cannot be a one-pager, that's not going to fly, why the exemption is appropriate in the circumstances. And by way of example, there is no precedent for such an exemption. One would provide for, amongst others, again, safety stats in relation to the incidents involving the relevant TMMs at a particular mine, the content of the risk assessment processes that we've discussed, and the further measures that you have been or will take to mitigate and eliminate any significant risks, the reasons why compliance with the relevant obligation and duties would be impractical or burdensome at the relevant time. It would be interesting to see what international trends look like as far as the implementation of these systems are concerned. You may need to make a reference to that. Reference may need to be made to the mine's implementation plan or strategy to comply with the regulations in the foreseeable future. Again, I say if applicable, depending on the objective of your application. And you should detail the existing health and safety measures in place in relation to the TMMs and its operators of pedestrians and operators and other TMMs, again, to mitigate, eliminate any significant risks in that regard. In practice, it would be advisable that the application for exemption is sent to the minister, but I do note there the minister may delegate any power conferred to him in terms of the Mine Health and Safety Act to the Chief Inspector in terms of Section 96 of the Mine Health and Safety Act. So provided that's delegated to the Chief Inspector, it can be sent to the Chief Inspector of Mines, and perhaps not the Minister, to the relevant PI or Principal Inspector for the applicable provincial region, and then perhaps also the representatives of the legal department of the Department of Mineral Resources, who can also be copied on the said application. It would be advisable to attach or at least address in the application proof of consultations with affected employees or their representatives, as per the requirements of Section 79, which also refers to such consultations. Again, as I've mentioned earlier, the minister or decision maker that's ultimately deciding on the application has a discretion to grant the exemption subject to any conditions that provide for the same overall protection and would result in the full application of the Act. So that should be considered when providing your exemption application to deal with possibly some aspects in that regard. The application in practice may take a significant period of time to finalize and obtain a decision from the minister. There's no specific time period provided in section 79. So importantly, it must be considered that the submission of the application for exemption does not automatically suspend the operations of the relevant regulations. So consideration must be given to the interim period pending the finalization of the application for exemption with the minister. Perhaps one potential option would also to make written submissions in your application in relation to that interim period, and why it would be superfluous to comply depending on your reasons that you've given or your objective of your application. There are no assurances that the submissions for the so-called interim relief may be successful, but it may provide you with a basis to seek further legal recourse. For instance, via a review in terms of the Promotion of Administrative Justice Act, or PAJA, or possible application to the Labour Court via Section 82 of the Mine Health and Safety Act, which deals with the interpretation and application of the Act. One further legal option that can be considered is an application for review in terms of PAJA on its own, or perhaps particular relevance if your application for exemption is rejected. An application for review in terms of PAJA can be made. And again, decisions made or instruction issued by functionaries, we say in terms of the MHSA, are administrative in nature, which would be subject to administrative law. Section 3 of PAJA provides, for instance, administrative action which materially and adversely affects the rights and legitimate expectation of any person must be procedurally fair. So that would be the basis in terms of taking the decision made, for instance, to reject the exemption application. And if it has a direct and external legal effect, it may be taken then possibly on review. And Section 6 of PAJA then contains certain basis of procedural substantive requirements on which you can use as a basis in your review application. And I've just highlighted a couple there, indicating that administrative actions should be procedurally fair. Irrelevant considerations may not be taken into account. Relevant considerations must be taken into account. Administrative action must be rationally connected to the information before the administrator, and the administrative action must be constitutional and lawful. So that's a couple of bases that you could use in a possible review application, depending on the decision and how it was made. That's the presentation. I don't know, there's a couple of Q&As, but I haven't been following them.
Yes, Warren, you can just check there. It's from Elaine Bota's side, and then also from Dion Victor. I don't know if you can see them. And
yes, I can see them now.
Comment with some of them. There's only the 3, or there's 4 open questions that you can deal with. I've dealt with the 1. And just for participants, just as I've indicated at the beginning, the recording will be made available on YouTube, and we will furnish you with a link so that you can view it later on, just shortly after the webinar.
I think I've dealt with some of the application. I see a lot of what I said is whether we need to apply for exemption and extension in terms of the regulation. I've dealt with that aspect under the exemption portion, and also when dealing with your exemption application, whether you should make written submissions in the actual application to deal with the interim period whilst the application for exemption is being considered. So that's something to consider. Again, there's also, as I've mentioned, the implementation or compliance timetables, which some regulators have required in certain provisions. Again, that should also be appropriately qualified in terms of realistic dates for compliance by the employer, taking into account the matters that you would need to consider, which I've mentioned. And then Dion said, is there not a duty now on the OEM to provide TMMs newly procured with all the relevant technology post 21 December 2022? There would be again, that would depend firstly on the employer must determine whether there's a significant risk at the particular operation first. So the onus is first on the employer to determine the significant risk of collisions in particular scenarios. That will then inform what is then required at the particular mine. But the onus and duty still remains on the employer to provide those systems. And that would be the scenario. Again, the OEM would have to comply with its duties in terms of the Mine Health and Safety Act, but there's no onus on the OEM at this stage, in terms of a 10 to provide TMMs with these technology. Did I understand, and this is Lana Boyd again, did I understand it correctly that an application of exemption should be made to the minister, and in terms of which section should it be? It is to the minister in terms of section 79 of the Mine Health and Safety Act, but I did mention that the minister may be able to delegate such power to the chief inspector in terms of section 96, if that is the case. So I think that's all the questions that I've seen, Peter. If there's no other questions at this stage.
You will see that there's just a question there from Amos.
Okay.
While waiting on the response from the chief inspector, how do we approach the principal inspector at the region?
I've also dealt with that, Amos. I think in your exemption application, you should actually copy the principal inspector on your exemption application. If you're referring to the response as far as your exemption application is concerned, and perhaps in your application already deal with the fact that you will be waiting for the finalization of the exemption application, which is beyond your control, and why you then say that if you are applying for exemption, why compliance in the interim would be superfluous. So I think you should make written submissions already in that application and copy the principal inspector so they're also aware that there is an application pending. So that if you are approached again by an inspector who wants to approach you and issue a 54, there would be again perhaps some basis to argue you've submitted your application for exemption and perhaps be able to take particular action that's taken by the department on review or on an urgent basis to Labour Court. Thanks, Peter. I think that's all the questions, but it'll be interesting to see how the matter develops in the next couple of months going on to next year. I think it's only been 5 months so far. So it'll be interesting once decisions are made on exemption applications and how employers deal with the implementation and timetables as going forward.
Thank you very much, Warren. Willem, I don't know if there's any further comment from your side. If you can just unmute and then before we close, I don't know if there's anything else that you just wish to add.
Peter, thanks. I've got no further comment, but certainly, especially the TMM regulations, you will have to analyze it very, very carefully to see what vehicles are are covered in which situations, which applies to pedestrians and vehicles, and which to vehicles between the vehicles, which may cause injury. And of course, a very important factor, as Warren has highlighted, is the question of risk assessment that you will have to do. And particularly relating to the density, not only of persons in the workplace, but also the density of vehicles in the workplace, whether it's on surface or underground. Because perhaps, you've limited it to such an extent that there is no significant risk. So that's very important to look at those things, and also the changes that you have introduced since the regulations have come into operation. COVID, I think there's more clarity now, because we were in some doubt as to what is the present status at the moment. because the department is silent, there was this letter, and perhaps it was issued by the principal inspectors, and perhaps they were authorized by, or delegated by the chief inspector to do that, because we must keep in mind that the only person that can issue guidelines validly is the chief inspector of mines, and then the chief inspector of mines must have it published in the government gazette. This was not published in the government gazette, so in any event, from that point of view, I don't think it's binding. So it is it's a recommendation at this point in time, but the department will approach it as if it's an instruction. So you must try and deal with the statements contained in that letter that was issued. But certainly, I think there's more clarity now than before about the status of the COVID-19 restrictions and obligations. But thanks to all of you who attended.
Thank you, Willem. I just want to say also thank you to all the attendees. You know, we will be in contact with you to furnish you with the PowerPoint slide presentations, and then also to the link to the YouTube recording. Thank you very much for making it extremely meaningful and useful to the mining industry. Then also thank you to Willem and Celeste and Warren for their very informative presentations. And as in closing, I just want to say, stay healthy, be safe, and enjoy the rest of your day. We're on 10:30 now. Enjoy your Monday. Thank you very much.
Thank you.